The clerk will open the court.
Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Good morning. The COVID-19 pandemic continues to require adjustments of the justice system. Social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, make it difficult for us to hold arguments in our courtroom. Accordingly, we are proceeding through remote connections. Court staff has made every effort to prepare us and counsel, but of course there may be glitches that will require patience. Otherwise, we will proceed as we would in person. The arguments are being live streamed and a recording will be available later today. We're ready to hear arguments in 19-280, Hinojos versus State Farm Lloyds from El Paso County and the 8th Court of Appeals District.
May it please the court, Ms. McCauley will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Ms. McCauley?
Good morning, and may it please the court. The court knows that this is a Prompt Payment Act dispute under Chapter 542 of the Insurance Code. In this case, the trial court dismissed the petitioner's Prompt Payment Act claims on State Farm's motion, arguing that it had paid an appraisal award and that payment served as a bar to prompt payment claims as a matter of law. The Court of Appeals affirmed that summary judgment on slightly different methodology. Instead, the Court of Appeals looked to the partial payment that was made earlier in the case and said, under a 2004 decision out of the Corpus Christi Court of Appeals called Brashears, that a reasonable payment at a reasonable time serves as an exception to the Prompt Payment Act. Neither of the courts below had the benefit of this court's decisions in Barbara Technologies or Ortiz. This case should be reversed. I will argue in 2 points. First, State Farm's persistence in arguing that an appraisal payment serves as a bar to a Prompt Payment Act claim cannot survive this court's decision in Barbara Technologies. And second, the Court of Appeals was wrong to rely on the Brashears decision and the exception it attempted to create for partial payment. Brashears is simply wrong, and we ask the court to disavow it on that point. Before I turn to the argument in the case, however, I want to highlight the characteristics of this particular dispute because these Chapter 542 cases appear to turn on their individualized characteristics, and these facts are not in dispute. The Hinojos suffered a loss at their home in 2013 and promptly submitted a claim to their insurer, State Farm. After an initial rejection, State Farm accepted the claim and made a partial payment on it in August of 2013.
Excuse me, I'm sorry to interrupt you, but let me just ask you that in light of Barbara Tech now, how could State Farm have remedied the situation by knowing what a fair amount would be to pay within that 60-day period, well before any type of appraisal process or anything like that had been invoked? So what should they have done? What could they have done differently?
I think what the statute encourages them to do with its purpose for prompt payment is to accept or reject the claim. They accepted. And when they accepted but did not accept in full, they wanted to make a partial payment. I suggest that because the parties' contract had a bilateral appraisal clause with no deadline or timeline, they could have immediately demanded appraisal in order to crystallize the amount of the loss and mitigate any statutory interest or attorney's fees that could possibly be incurred as a result of the dispute.
What about the insured requesting an appraisal?
As I say, it was a bilateral clause. The insured the petitioners could have requested appraisal in this case, but unlike State Farm, petitioners' request for appraisal would not have ended the dispute. And let me explain what I mean by that. After Barbara Technologies, we know for sure that the insurance company, or if the insurance company participates in appraisal, they don't admit liability on the claim. That is not an acceptance. And because of the structure of insurance disputes in the state of Texas, according to our legislature, the insured has a breach of contract cause of action, has potentially bad faith claims, and has prompt payment act. If the Hinojos had simply demanded appraisal in August of 2013, when their claim was only partially paid, the most that they could have hoped to accomplish by that appraisal is to crystallize the amount of the loss and pray that State Farm would pay it promptly. They would not have been able to, by appraisal, get complete relief, because Barbara Technologies tells us prompt payment damages would not have been available without the Hinojos going back and establishing liability, if that answers the court's question. So even though appraisal was available to both parties, it served a different purpose for both parties.
It kind of depends, though, I think, because if the request for the appraisal is made within that 60-day period, it may be, and we have not held this way, but it could be that if that appraisal request is made within that period of time, that it is not until that appraisal comes back that the 60-day begins, because of the documentation not being back that they need to depend upon. So it could go, it could be that either one of them should request.
I understand what you're saying, Your Honor, but I think that position would be completely inconsistent with what you have already written in Barbara Technologies for two different reasons. The first is you acknowledge that appraisal can't serve as a bar unless the legislature decides that it's going to serve as a bar. Because the legislature did not put anything into the statute concerning appraisal, it would not be up to this court to then insert into the timetable the notions of appraisal. The second way in Barbara Technologies in which you also resolved the question about whether or not they are demanding additional items, you analyzed the plain language of the statute and said a demand for appraisal is not the equivalent of a request for all items.
Well, but that really was a different situation than what I'm talking about, because that was what happened in this case, which is typical, and that is that the appraisal is not requested until way down the line after a suit is filed. And if things are sped up, then it could be different, I believe. I think those are open questions.
I certainly understand what you're saying, Your Honor, and I would probably resort to this court's 2007 opinion in State Farm versus Martinez to further the discussion. And if the court will recall, that case was not an appraisal case, but it was an interpleader case. And you were examining whether or not, and it was a State Farm case too, whether or not State Farm could use an interpleader action to cut off the Prompt Payment Act damages. And you analyzed first whether or not the Prompt Payment Act even applies in interpleader, given the long-standing and valuable purpose of interpleader. And you decided that because the legislature did not include interpleader as an exception to the Prompt Payment Act time period, you could not import interpleader for that purpose. On the other hand, when you analyzed interpleader in the context of the plain language of the statute, you were able to construe interpleader because it is rival claims and the insurance company is giving up all that it can under the insurance policy, under the life insurance policy. You construed that as payment. So you were very reserved in how you handled interpleader, which is a much more favorable circumstance for State Farm because they really are an innocent party with funds. And that's what you were recognizing is in Martinez, is that given the purposes of the statute, when the insurance company is basically a bystander, the purposes of the statute are not served by imposing Prompt Payment Act interest or attorney's fees on the insurance company who interpleads. On the other hand, appraisal is the opposite. The legislature did not provide for appraisal, and there's nothing about appraisal that serves the purpose of divesting the insurance company, making them an innocent. They are holding the money in their pocket for the entire time of appraisal, and that statutory incentive for them to promptly and fully pay is completely eviscerated when you import appraisal. I would also suggest that not only does Martinez tell us that that is not what you should do in this case, but also because the legislature has already amended Chapter 542. Chapter 542 is now 542A, and even though the A portion does not apply to this case because it's not effective until 2017, the legislature did have to look at whether or not, with percolating cases, whether or not it wanted to incorporate appraisal, or as the Court of Appeals did in this case, incorporate some sort of a reasonableness in order to perhaps alter the balance a little bit to still create the incentive for prompt pay, but not create an incentive for litigation. And instead of either including appraisal or the reasonable exception that the Brashears Court created, 542A altered the scheme so that there's reasonable notice that is required, and it altered the attorney's fees to a sliding scale. So even when the legislature decided to speak and alter the balance, it didn't do so by incorporating an appraisal process as a bar or altering the time limits with appraisal, and it certainly did not incorporate a reasonableness exception under Brashears.
Ms. McCauley, if I can get some clarification, your position is that when State Farm paid the $1,995, they accepted the claim at that point. Is that correct?
Yes, Your Honor, that is correct. Not only our position, but it is State Farm's position as well on page 3 of their report.
Or actually, I should be a little more clear. They accepted the claim sometime immediately before they paid the $1,995, because once they accepted it, they had 5 days to pay it, and they basically did both at the same time. But it's also, you agree with State Farm that the fact that they agreed to pay that $1,995 does not mean that they were liable to pay the $1,995.
I'm not sure that I'm following your question.
I wrote separately in Barbara Tech because I disagreed with the majority. The majority said that the voluntary payment made by the insurer to the insured does not establish the liability, that's in quotes, liability or the judicial determination of liability that the Prompt Payment Act requires. And you agree with that the fact that they paid $1,995 does not mean that they're liable under the policy?
I do not agree, although I'm not sure the court needs to decide that for purposes of this case, but I can explain. The statute does not differentiate between accept in part or reject in part. The statute requires an accept or a reject. The statute does contemplate that an insurer who has accepted might partially pay in the next section, but I think it is an open question under Barbara Technologies whether or not the voluntary payment of the appraisal award in a context such as this, where there's been a preceding acceptance, could serve as an acceptance of liability. I don't see State Farm arguing at this point that they are not liable, or that we do or do not need to establish that they are liable. But I think the fact pattern in this case, the reason that may not be something the court needs to decide is, unlike Barbara Technologies, we do not have cross motions for summary judgment in this case. We do
prior to the payment of $1,995. Had Hinojos made a claim for a particular amount?
It is my impression that the answer to your question is yes, Your Honor, but that is not contained in this record that I have been able to find.
So how do we know whether they paid the claim or not within 5 days?
I'm not sure we know for sure, but we know that there's no dispute between the parties whether or not State Farm was in compliance with the timetable for the partial payment. We have not alleged that they
You refer to it as a partial payment. Why do you call it a partial payment?
Because what we do have in the record is the letter from State Farm tendering the payment and explaining they are not paying everything that the Hinojos asked for. And they're explaining why they don't pay the rest not just because they dispute the value of the loss, but they're disputing coverage on some aspects as well. So we know they did not pay in full. Indeed, we know from not only the parties' briefing and the record in this case, but State Farm's agreement that they really did not pay but about 10%, approximately 10% of the ultimate value of the claim.
Right, the ultimate value as determined later through appraisal. But what I'm getting at is, how do we know whether they paid the claim that was actually on this record? How do we know that they paid the claim or only part of the claim within 5 days of accepting it before appraisal?
It is I could give you, I can't give you the exact page, but it is attached to State Farm's motion for summary judgment. It is the letter. You'll have to go to the second letter. They originally sent it, I think, to the wrong address, but their letter is attached to their motion for summary judgment, demonstrating that they tendered a partial payment in August of 2013 and did not until 2015 demand appraisal.
And so is it fair to say that they only accepted the claim as to the extent of that amount that they tendered? That they rejected the claim to the extent of any amount greater than what they tendered?
State Farm has not taken the position that they have rejected in any way. They take the position that they accepted the claim in August of 2013. And I see that my time is up. Justice Busby, I didn't mean to cut off your question though.
I was just going to ask if the Mextex decision from this court sheds light on that, Justice Boyd's question, in your view, because of the way that they defined claim, that we define claim as the amount ultimately determined to be owed. And when you look at it from that perspective, would it then not be a partial payment?
You're absolutely correct, Your Honor. Mextex does define claim, and the court, in its unanimous as to at least that interpretation of the 051 definition of claim, determined that it was the sums that remained owing that were the subject of the prompt penalty damages in that case, not the previously paid partial payment. Yes, Your Honor, it is directly on point. Thank you so much.
Any other questions? Thank you, Ms. McCallie. We'll hear from the respondent.
May it please the court, Ms. Lorber will present argument for respondent.
May it please the court. To be clear, State Farm is not arguing that its payment of the appraisal award is what shows it complied with the statute. It's also not asking this court, it's not advocating for a reasonableness exception. The question before this court can be answered by the plain language of the prompt payment statute. The statute is intended to promote prompt payment of claims, and it does that by requiring certain timelines to be met for acknowledging the claim, requesting necessary information, investigating, accepting or rejecting, and then paying the claim. The plain language of the statute controls when payment is made, not how much must be paid. If an insurance company complies with each of the statute's timelines, then the insurance company complies with the statute. The statute's goals are fulfilled when the claim is promptly considered and promptly paid. It prevents sitting on a claim and not determining it. What the statute does not do, there's no provision in the prompt payment statute that provides a remedy when the insurance company makes a prompt but perhaps incomplete payment. That would be remedied by different causes of action. For example, if an insurance company does not pay enough, the insured would have a breach of contract cause of action. If the insured believes that the insurance company did not pay enough because of some bad faith conduct, then they would have a Chapter 541 claim. But no
Ms. Lorber, if I can interrupt, what was the claim that State Farm accepted when it paid the $19.95?
The State Farm accepted their claim for hail damage, wind and hail damage.
And do we know from the record, your opposing counsel says we may not come up with a specific amount, but we can certainly tell from your client's letter attached to your summary judgment pleading that we know that the amount that State Farm paid when it paid $19.95 did not cover all that the insured claimed. And so I'm struggling with the idea of whether, under the language of the statute, State Farm paid the claim within 5 days, or did it accept part and reject the rest? Because your argument is all you got to do is pay something and now you've paid the claim. Well, if the claim is $10 million and you pay $100, how have you paid the claim?
So I think I understand multiple parts of your question, and I'm going to try to address each of them. So the insured claimed, the Hinojos claimed, there was a storm and my house is damaged. And State Farm says your roof was not damaged by wind and hail, so it is not going to be a covered loss. It was wear and tear. But the interior of your house did get water inside during the storm, and we will pay for the interior. So State Farm paid the covered aspects of the claim, accepted and paid the covered aspects. But secondarily, I think the statute itself puts claims into two buckets. It has a reject and it has accept. And in 542.057, the legislature defined that accepting a claim means notifying the insured that you're going to accept and pay in full or part. So a partial agreement to pay, agree to pay on the claim, is in the accept bucket under the text of the statute. And the legislature knew how to impose remedies for only a partial payment of a claim if it wanted to do so. In other sections of the insurance code regarding HMOs and PPOs, which are 1301.137 and 843.342, the legislature specifically requires HMOs and PPOs to pay a fee when they only pay a portion of the amount of the claim. But such language is not contained in 542.
The definition that we have to look at of claim for purposes of 542, we talked about in MEXTEX, and we said that claim is defined, focuses on the amount that must be paid, which limits it to the amount that's ultimately determined to be owed. And we said that would be net of partial payment. So why doesn't MEXTEX resolve this case?
Well, I think MEXTEX, neither party in MEXTEX raised the question that is being raised in this case.
Right, and I saw that argument in the brief, but we're just looking at the plain text of the statute, and the way that we interpreted it in MEXTEX was that claim is the amount that's ultimately determined to be owed, not the amount that the insurance company may elect to pay in response. And so basically the prompt pay damages can still accrue on the unpaid portion of the claim. So why is that not? Are you arguing that that's not a correct construction of the statute? That we got it wrong in MEXTEX?
Yes, Your Honor, and I believe the reason that language got there is because that's what both parties were arguing. Both parties in that case were arguing we should, well, one party was, the insurance company was arguing, well, we agree we have to pay interest on the part we haven't paid yet. I believe that they invited an incorrect interpretation of the statute. If you look at the statute language.
But if you think through it logically, taking the definition from MEXTEX that Justice Busby has highlighted for you, if the insured says, if the insured says, I got hail damage, I'm hereby making a claim for all covered losses resulting from this hail damage, and the insurer says, okay, here's $100, and the insured says, wait, I think my covered losses are much higher than $100. And the insurer says, well, sorry, we disagree. We accept your claim. Here's your $100. So now the insured demands appraisal and it comes back at $1 million. It's your position that the insurer accepted and timely paid the claim?
For purposes of the for 542, yes, they complied with each of the plain language requirements in Chapter 542. But that's not to say the insured doesn't have a cause of action. The insured would have a bad faith.
But they have no right to attorney's fees or interest resulting from the insurer's refusal to pay you know, 999 point whatever $1,000 that were legitimately claimed.
I believe that they would not have that remedy under this statute, but they would have a cause of action for breach of contract and under 541, both of which could also entitle them to attorney's fees.
Under your construction, what happens when an insurance carrier determines that the amount of the claim is less than the insured's deductible, and so pays nothing, accepts the claim, but says that the amount is less than the deductible? Would you call that also a payment under the statute that would conclusively defeat any further claim for interest or attorney's fees when later the insurance carrier decides that the claim is that it owes more than it originally calculated?
Your Honor, that question, I believe, was squarely answered by Barber Technologies. And Barber Technologies defined what is an acceptance and what is a rejection of a claim under the statute. And the court in Barber Technologies said, if you conclude that it was under your deductible, you're concluding you have no liability and you are in the rejection bucket. But if you accept that you have some liability under the policy, you go into the acceptance bucket. This case is different because it is in the acceptance side of the statute rather than the rejection side of the statute.
So you're saying that it's just a calculation above or below the deductible that constitutes what a partial payment might be, and then in compliance with the statute?
Well, Your Honor, we actually argued, we had disagreed, State Farm had disagreed with that. Throughout Barber Technologies, we argued that that didn't make sense in our motion for rehearing in Barber Technologies, but it's very clear in the court's opinion, I believe, that that's what the court decided in Barber Technologies, that under the deductible was a rejection and over the deductible is an acceptance, at least the way that I've read Barber Technologies a lot of times, and I think that is what the court says. But I do want to point out that the interpretation that the other side is asking for in this case, they would like the court to reject Brashears. And they need the court to reject Brashears if they can win in this case. But it also is going to require this court to reject its own discussion of Brashears in Barber Technologies. In Barber Technologies, the court cited favorably to both Brashears and the Fifth Circuit's decision in Maynolly. And it specifically said those two cases were cases where they made what is being called in this case a partial payment. They did not pay, the insurance company did not pay everything the insured wanted, but it made a prompt payment, and it therefore followed all the deadlines and made the payment within the deadlines, and it therefore complied with the statute. And the fact that an appraisal was later done and the appraisal concluded that more was owed and the insurance company paid it does not mean that their original compliance with the statute. It doesn't change that. The court specifically said that it agreed with that reasoning in Brashears, and it agreed with the summary judgments on those facts in Brashears and Maynolly. And that's exactly the same position that we're here in today. And the other side is arguing, Ms. McCauley is arguing that we're asking for a reasonableness standard, and we're not. If you look closely at Brashears and at Maynolly, the reasonableness language was not the key. The key to both of those decisions was that the payment was prompt. A prompt payment was made, and that complied with the statute. And then the statute governs the period of time initially when the claim is handled, approximately 60-day-ish period at the beginning of the claim. And if you do everything you're supposed to do in that time frame, the fact that there's an appraisal later becomes irrelevant to the fact that you have already complied with the statute. And this court wrote favorably about that in Barber Technologies and needs to apply that language here in this case and affirm the summary judgment.
Ms. Lorber, couldn't you all just resolve this by asking for an appraisal early in the process? So I'm hoping that after Barber Tech, you all are changing some of your contracts. It'd be very much clearer for everybody if it was in the contract, and ask for that appraisal process early on, since it is a mechanism to help resolve this disputes. We all agree on that, and that's going to resolve all these issues. So is that what you all are doing now?
I believe so in some cases. There has been less appraisal or less resolution of cases by appraisal since Barber Technologies. But I think what you're suggesting, Your Honor, would be great. And I think Barber Technologies leaves the court open to holding that would be okay, because in Barber Technologies, the court said, you weren't requesting additional information on claims handling because you didn't make your request for appraisal until litigation. There was a difference, like you mentioned, Your Honor, a difference in requesting appraisal during claims handling or requesting appraisal during litigation. And in that case, it wasn't requested until litigation, so that wasn't enough to sort of stop the clock. I agree that it would be appropriate here. I mean, if an insurance company believes part of the claim is owed, it promptly pays that, and then sends the rest of the case to appraisal, I think would be completely consistent with the intent of the statute to get whatever payment is undisputed to the insured as soon as possible, and then try to get the rest of it resolved quickly.
But the appraisal here wasn't during claims handling, right?
It was not, and I yes.
Have we already said that a partial payment within 60 days doesn't conclusively defeat a Prompt Payment Act claim as to remaining payments made under the policy?
I don't believe the court has addressed that question. I am not aware of a case other than MEXTEX that dealt with partial payment. I think all the cases that I am aware of have come up in the context of no payment was made and the insurance company then took the risk of later owing it and having rejected the claim.
Or no payment above the deductible.
Correct.
Right, because if you count the agreement to pay minus the deductible, then even Barber Tech involved that kind of partial payment, right? I mean, right. They agreed that they owed something. They just took the position it was less than the deductible, correct?
Yes.
Okay.
I understand your position that there shouldn't be any reasonableness test or good faith test, but I'm looking at the word delays, and that's how this is triggered. It's when the insurance company delays payment, and it seems that perhaps the hypothetical where the payment, the claim's $1 million and they pay $1,000 just to say we paid something. That seems kind of like a delay. A purposeful delay. Whereas if the claim is $1 million and they pay, they send their guy out there and they end up paying $800,000 or $900,000, that's not a delay. That's a good faith attempt to pay the amount. Why wouldn't there be, because of that word delay and sort of the intent element that's embedded in that word? Why wouldn't there be some kind of a good faith or reasonableness analysis that we need to do?
So. I don't see a reasonableness analysis in the language of the statute. I understand the court's position in Barber Technologies that we need to follow the language of the statute. And the language is a little confusing, but I think that the language itself shows what the legislature was trying to do. And they were trying to get payment made. They were trying to get the cases resolved and payment made quickly. And they weren't, in this statute, talking about the amount. You get to the amount of liability through different means. And so in this case, as long as the insurance company does each of these things and does them on time, it complies with this statute. But again, like I'm saying, this court talked in Barber Technology.
You agree that interest is only owed on the amount that's unpaid, right?
At most.
So to say that they're not getting toward the amount, does that make sense? Because it's just simply a mathematical calculation of what amount of the claim went unpaid, and what is the calculate 18% interest on that for the time period that it went unpaid.
So, Your Honor, you don't get, under the structure of this statute, you don't get to liability and the amount that needs to be paid until you get to 060, and you don't get to 542.060 until you get past each of the other requirements. If you comply with each of the other requirements, then you don't get into the remedy phase. And it's only if you do not comply with 055, 056, 057, 058 that you, any of those, if you don't comply, you get into the 060. And 060 then says, in order to
Your argument is that it's a binary choice. Either some amount is paid, in which case you have no Prompt Payment Act claim whatsoever, or it's not paid or not accepted, and you owe interest on the entire amount of the claim.
I believe
there's no calculation as to interest owed on amounts unpaid.
There are situations where this could come up. For example, here we changed so initially rejected the claim, very quickly changed our mind and paid the claim and did it within the timelines of the statute. But there could be situations where it takes a lot longer to get there. And so they originally rejected the claim more than the 60-day period, or more than the 5 days after acknowledging that we owed it, the violation, but then paid it fairly quickly, a month or 2 or 3 months later. There would be a calculation on what was owed for that period of time in which we were not in compliance with the statute. But in this case, when it was done so quickly within the language of the statute, then you don't get to the liability into the calculation. And I think that's what the legislature intended. By giving the 60-day period, they're giving time for the insurance company and the insured to work it out and to get to the place where they've accepted and paid the claim. And I don't want the court to think that by saying they complied with this statute that we're saying there's no other causes of action. As the court talked about in both Barbara Tech and I believe Ortiz, just because you complied with the statute doesn't mean you don't have a breach of contract claim if we didn't pay enough, and it doesn't mean you have a bad faith claim if the reasons we didn't pay enough were because of bad faith. In this case, the Hinojos have dropped all of those claims, but in this statute governs hundreds of thousands of insurance claims across the state, whether or not appraisal is involved. And I believe is read the same way, or should be read the same way in each of those cases. And so particularly when there's no appraisal, bad faith and breach of contract are still on the table and can remedy some of the court's concerns. See, I have a few seconds left if anybody has any further questions.
If we disagree with your premise with regard to whether paying some amount less than the insured is demanding and is ultimately determined through appraisal, if we conclude that that is not accepting and paying a claim, do you have any other basis to prevail in this case? Or do you lose at that point?
Well, I don't think we lose, Your Honor. If I can finish answering the question over my time, thank you. I think, yes, if the court disagrees that partial acceptance and payment fits in the acceptance bucket and instead would fit in a rejection bucket, then I think what happens is we go to Barbara Technologies and it becomes a fact question. The other side is not, we all agree that if this court concludes that this case somehow falls into the Barbara Technologies bucket, then we have to go back to the trial court because our liability has not been established. It would just mean that if the court were to decide that partial payment is a rejection or partial acceptance is a rejection, yes, then this would fall under Barbara Tech and we'd go back and we'd litigate who wins or loses.
Any other questions? Thank you, Ms. Lorber.
Thank you.
Ms. McCallie, I think you have 5 minutes for rebuttal. You're muted, Ms. McCallie. You're muted.
There we go.
There you go.
I think I've got it. Thank you so much. A Zoom hiccup. I apologize. Justice Bland, if I could return to your question for one moment on the appraisal side. You asked the question whether or not the court has already decided that particular issue, and I submit to the court that you already have. On April the 17th of 2020, you reversed 3 cases, 2 of which were State Farm cases. One was Alvarez, one was Lazos, and the other one was Perry. You reversed those cases and said that the lower court's holding that Prompt Payment Act damages were not available was error in light of your opinion in Barbara Technologies. The insurance company in those cases was in the identical posture of State Farm in this case. There was a partial payment, there was an appraisal, and then there was a full appraisal payment. And this court said any bar to the petitioner's Prompt Payment Act damage claim was error, and you reversed those 3 cases. So I think you have already decided those. And I would return to Justice Busby's question about MEXTEX. I don't think your question is eviscerated by the fact that the parties were not arguing about whether or not they owed some prompt payment damages. Your point is the court construed the statute and specifically the definition of claim. And you concluded that the definition of claim means that in a partial payment circumstance, Prompt Payment Act damages are still accruing on the unpaid sums. So in this case, your precedent tells us what happens in this case on the appraisal side of the claim. On the Brashear side of the case, I'm not sure that I understand how State Farm runs from reasonableness, because now they're presenting the court with a facts and circumstances test. Under any set of circumstances, however, if this court is going to construe this statute to mean that an insurance company complies with the Prompt Payment Act when it pays what it believes it owes, that has rendered the purpose eviscerated. It's an absurd construction of the statute. State Farm and every other insurer can pay what it reasonably believes it owes without the incentive of the legislature. The legislature determined that 18% and attorney's fees was the impetus needed to promptly and fully handle and pay claims under Chapter 542. And an insurance company did not need to be acting in bad faith in order to be subjected to those penalties. For State Farm to suggest that these petitioners would still have—
But it does, counsel, have to be delaying. It has to be delaying in order to be subject to the penalties. And I'm struggling with that word. And it seems that there's a difference between delaying payment and having a disagreement about the amount.
I can see the concern, and I think in a way it harkens back to the court's struggle over whether or not 058 applies or 060 applies. And it seems to me that we need to look at least at the 060 question of whether or not State Farm is in compliance. Yes, the entire, as Justice Heck said in his dissent, both 058 and 060 are directed to avoid delay. But 060 specifically talks about not being in compliance. And for an insurance company to only pay a portion of the value of the claim renders it not in compliance with Chapter 542. And so every time State Farm tells you that they have timely paid, they must either be referring to a timely but partial payment in August of 2013, or they must be referring to a payment they made in 2016 that was 2.5 years after they accepted that benefits were owing in this case, and say that they get to construe this statute as barring any penalties if they just pick a number. And that's not what this statute means. You are not in compliance, and you're not in compliance from the beginning. Otherwise, an insurance company simply has the incentive to hold the money. If you restart the timetable based upon the appraisal process or upon an ultimate full payment, then you have ignored the timetable that the legislature chose, and you've allowed an insurance company to disadvantage its insurer, force them to go and get an attorney in order to chase the money. That is the delay that the legislature envisioned was not the way they wanted insurers in the state of Texas to handle their business. We ask that you reverse.
Any other questions? Thank you, Ms. McCallie. The case is submitted and the court will take a brief recess.